Unit 4. So the Banking Law Unit 4 contains the Negotiable Instruments Act 1881. So what do you mean by negotiable instrument? Negotiable instrument is a piece of paper which entitles a person certain sum of money, and this instrument is transferable by mere delivery or endorsement. So this is basically a piece of paper, and the person who is holding this instrument is entitled to certain sum of money from a different person, and this person who is holding this instrument can transfer this instrument to another person by mere delivery or by endorsement. So section 13 of the Negotiable Instruments Act defines a negotiable instrument as: negotiable instrument means a promissory note, a bill of exchange, or check payable either to or to bearer, either to order or to bearer. So it is payable either by order of a certain person, or it is directly payable to the bearer. The person who is holding the instrument is called bearer. Kinds of negotiable instrument. So we have three kinds of negotiable instruments. The one is a promissory note, the next is a bill of exchange, and the third is check. So promissory note. So what is a promissory note? A promissory note is an instrument in writing which is not a currency note and containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So promissory note is nothing but it is a negotiable instrument. So it is basically a piece of paper. So for example, if I take a piece of paper and I write on it, I promise to pay Mr. X 1000 rupees, and I take this note and hand it over to Mr. X, then I will be liable to pay Mr. X 1000 rupees. So this is a promissory note. I am promising Mr. X to pay 1000 rupees. So it is basically a piece of paper where one person promises to pay a certain amount to another person. Illustrations. I promise to pay B or order rupees 500. So I acknowledge myself to be indebted to B in rupees 1000 to be paid on demand for value received. So I promise to pay B or order rupees 500. As soon as he writes this note and hands it over to B, then he will be liable to pay rupees 500 to B. So this is a promissory note. The person who is making this instrument is called maker, and the person who is getting paid here, to whom we are delivering this note, is a payee. Essentials of a promissory note. So it should compulsorily be in writing. The note should be compulsorily be written in writing, and there should be a promise to pay. It should contain a promise to pay, specifically written as promise to pay. Then it should be unconditional. There should not be any condition imposed in that. For example, in this illustration, if he writes it as I promise to pay B only if he does a certain thing for me. So he is imposing a condition here. If a condition is imposed, then it is not a promissory note. No condition should be imposed, only a promise to pay should be there. Unconditional. Then money only. The payment should be money only. There should be no property or asset. Certain parties. The party to whom we are paying this instrument, we are promising, should be written properly. Like for example, I promise to pay Mr. B. The Mr. B should be written properly, correctly, certain parties. Then signature. The one who is making this instrument should sign this instrument. Only then it is valid, signature. The case law is Gay versus Rook. So in this Mr. Rook write a note to Gay as IOU Gay, the sum of $17 for value received. So it was held that this is not a promissory note, as the language used was not proper, and where promise to pay cannot be deduced from this letter, from this note. You cannot say that a Rook is promising here to Gay that he will pay. There is no promise here. The language used is not proper. So this is a promissory note. The next instrument is bill of exchange. So what is a bill of exchange? Under section 5 it contains bill of exchange. So bill of exchange is also an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of instrument. So in bill of exchange, it is also an instrument, it is also unconditional, But unlike promissory note, here the maker will not pay, is not promising to pay. Here the maker will order someone else, a third party, to pay on his behalf. So in bill of exchange, he will order a certain person, the maker will order a certain person to pay on his behalf to a third person. So essentials of a bill of exchange. So it should compulsorily be in writing. There must be an order to pay. So the person who is making this instrument should order someone to pay on his behalf. It should be unconditional. There should not be any condition imposed on it. Money and money only. The payment should be money only. Three parties. Here there are three parties involved. One is a drawer, the one who is making the instrument, the one who is making the bill of exchange, or the one who is signing the instrument is a drawer. The next is a drawee, to whom it is addressed. To whom the drawer is ordering to pay money is the drawee. So a drawer is the person who is making the instrument, and he is ordering a certain person to pay, and he is a drawee, the one who is paying is drawee. The next is a payee, to whom a payment is to be done. So there are three parties. A drawer who will write the instrument, and a drawee to whom he is ordering to pay, and the payee to whom it is to be paid. The instrument is in the hand of payee, so he is the holder because he is getting paid. Indication of a drawee with reasonable certainty. So the drawee name should be mentioned here. In the case Ruff versus Webb, so Mr. Ruff was a servant of Mr. Webb. Ruff was working as a servant of Mr. Webb. So his salary was due from Mr. Webb. So Webb sent Ruff to Mr. Nelson with a note writing it as, Mr. Nelson will much oblige Mr. Webb by paying to J. Ruff or order 20 guineas on his account. So he is ordering Mr. Nelson to pay his servant 20 guineas on his behalf. So it was held that this is an bill of exchange. Even though the language is polite, the Webb is ordering Nelson. Here there is an order to pay, and the drawee name is also mentioned properly. So it is a bill of exchange. Cheque. Cheque is also a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand. So cheque is also a bill of exchange, but here the order to be paid is not done to just any person. It is only done to a bank. So we are ordering bank to pay on our behalf. This is a cheque. In bill of exchange, we can order any person to pay on our behalf. But in a cheque, only we order bank to pay on our behalf. So this is called cheque. Here the drawee is a bank. Case Cole versus Milson. In this case, the cheque was framed as per all the regulations. Everything was written properly, but it was written as payable to cash or order. So the person to whom it is paid was not specified properly. Hence it was held that it is not a cheque. The person to whom it is paid should be specified properly. The bearer should be specified properly, or the payee. The next is difference between bill of exchange and a promissory note. The first is a definition. So bill of exchange is issued to order the debtor to pay creditor some certain sum of money. We are ordering someone else to pay money on our behalf. But in a promissory note, it is issued by the debtor himself and he is promising to pay. The promissory note, the person who is making the instrument is promising to pay. Next is the section. Bill of exchange is in section 5 and the promissory note is in section 4 of the Negotiable Instruments Act 1881. The next is issued by. Bill of exchange is issued by the creditor and the promissory note is issued by the debtor. Parties involved. Bill of exchange, there are three parties: drawer, drawee and payee. So drawer is the one person who is making the instrument, drawee is the person to whom we are ordering to pay, and payee is the person who is getting paid. But in promissory note there are only two persons. The one is maker or drawer, the one who is signing the instrument, and the next is payee, who is getting paid. The next difference is acceptance. In bill of exchange, the drawee needs to accept the bill of exchange. If it doesn't accept the bill of exchange, it will be dishonored. But the promissory note, there is no need to accept a promissory note. There should be no acceptance required. Liability. In bill of exchange, liability of a drawer is a secondary and conditional. But in promissory note, liability of drawer is a primary and absolute. The next difference is the dishonoring of instrument. In bill of exchange, the notice is served to all parties. If the instrument is dishonored, if the instrument is rejected, in simple words, Then the bill of exchange, the notice is served to all parties that the instrument has been dishonored, all the three parties. But in promissory note, no notice is served on dishonoring. Copies. In bill of exchange, you can create copies of that instrument, but a promissory note copies can't be created. It is payable to, the bill of exchange is payable to drawer or payee. So the one who is making the instrument can take the payment, or the payee to whom we are going to pay it can also take the payment. But in promissory note, the one who is making the instrument, the drawer, can't be payee, can't accept the payment. So this is difference between bill of exchange and promissory note. The next is the difference between bill of exchange and check. So first we have to write a definition, where a bill of exchange we order to any person to pay, but in check we order only banker to pay. Then a bill of exchange presented for acceptance. So bill of exchange when presented to the drawee, it is presented for acceptance. The drawee should accept it first to honor it. But in check it is directly presented for payment, because we are giving it to bank. The bank no need to accept it. We are presenting it for payment. The next difference is in bill of exchange dishonored by non-acceptance. So if the drawee don't accept the bill of exchange, then it is dishonored. But check is not dishonored by just mere non-acceptance of the bank. The next difference is in a bill of exchange, it is payable after a fixed period, but check is payable on demand. As soon as you present check to the bank, it is payable. The next is a bill of exchange. A drawee can be any person. So the person we are ordering to pay can be any person in bill of exchange. But in check, the drawee can be bank only. So this is the difference between bill of exchange and check. The next is the difference between a promissory note and check. So first we will have to write a definition of a promissory note, where the person is promising to pay. In check we are ordering a bank to pay. Then section numbers. Promissory note is in section 4 and a check is in section 6. Then issued by. The promissory note is issued by the debtor and the check is issued by the creditor. Then parties. In check we have 3 parties: the drawer, the payee and the bank. And in promissory note we have only 2 parties: the drawer maker and payee. Then acceptance. In both the acceptance is not required. Then payability. The promissory note, drawer and payee can't be same person. So the one who is making the extra instrument cannot take payment in promissory note. And in check can be same. Both the drawer and payee can be same. The one who is making the instrument in check can also accept the payment. Grace period. For promissory note, the grace period is 3 days, but check there is no grace period. Stamping. The promissory note has to be sufficiently stamped, but in check there is no need to stamp. Validity. The promissory note is valid for 3 years, whereas check is valid only for 6 months. Liability. The promissory note primary and absolute. The liability is primary and absolute, but in check liable only if no notice of dishonor is served. So this is difference between bill of exchange and check. The next important concept is holder. Section 8 of the Negotiable Instruments Act speaks about holder. So the one who is holding the instrument is a holder in simple terms. So a holder of a promissory note, bill of exchange or check means any person entitled in his own name to possession thereof and to receive or recover amount due thereon from the parties thereto. So he is a holder of the instrument in his own name and he is entitled to take money of that instrument, due from that instrument. He is the holder. The next is section 9, holder in due course. So holder in due course means he is the original owner. He is not a fake owner of that instrument. So that is the difference between holder in due course, because the instrument can be taken by a theft also, right? So if it is taken by a theft, then he is just an holder. He is not a holder in due course. Only the true owner of that instrument is a holder in due course. So what is the definition of holder in due course? Section 9. Any person for consideration, he has taken it for consideration and became a possessor of a promissory note, bill of exchange or check. So any person after paying some consideration, he became the possessor of that instrument and it is payable to bearer or payee or endorsee, or it is payable by order. Before the amount mentioned in it became payable, so before it expires he became the possessor of it, owner of it, and without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. So he totally believed that the person from whom he is taking the instrument didn't have any defective title on that instrument. So he is a holder in due course. So elements. So there should compulsory be an consideration. He should have taken that instrument by paying some consideration. then before maturity, he should have obtained that instrument before it matured, before it expired. Then complete and regular, there should be no defect in title of that instrument. And good faith, he should have obtained this in good faith. So he is the holder in due course, the original owner of that instrument. Case Sarju Prasad versus Rampyari Devi. So in this, the plaintiff paid 2,459 rupees to the defendant in a note, with a note. But in the note he wrote it as it is payable to X. He wrote X's name. So the plaintiff brought a suit against defendant to pay him money, but it was held that since the instrument was in the name of X, only X is the holder in due course and only he should be get paid. The rights and privileges of a holder in due course. So what are the rights and privileges that a holder in due course gets? First, section 118, presumptions. So that the holder is a holder in due course and the burden of proof is not on holder. So if a holder is in due course and is having that instrument, then the burden is not him to prove that he is a holder in due course. If the opposite party is telling him that he is not holder in due course, then only he should bring proof. So until that he is presumed that the holder of the party is holder in due course. Holder of the instrument is holder in due course. Presumption. The next is a privilege against inchoate stamped instruments. So a blank instrument. If you give a blank instrument without writing anything on it, without writing any amount or anything on it, or the person's name, and blanked and signed the instrument, so holder has the authority to fill it. If you give a blank instrument without writing any money, then the holder has authority to fill his own money in it. So privilege against inchoate stamped instruments. So in this case, Baxendale versus Bennett, the defendant gave a blank stamped bill to H. He gave a blank stamp to H. H returned it back to defendant, and the defendant kept it in a safe, but his clerk stole it, and he issued that bill of exchange by writing his own name. So the defendant was held not liable because it was obtained by theft. The clerk was not holder in due course. The next privilege is a fictitious drawer or a payee, section 42. So fictitious payee is person whom a drawer never intended to have the payment. So the drawer will write the person's name to whom he want to get paid, but that person didn't exist. If he is a fake person and the drawer never intended to have that person get paid, then he is not liable. Fictitious drawer, not liable for fictitious payee. The next is the prior defects, section 58. The party liable to pay an instrument cannot say holder lost it or obtained it by fraud or for unlawful consideration. So the person who is paying the holder in due course, he cannot say that there is defect in this title from whom you have obtained or you have obtained it by fraud or something. If there is an instrument, then he will have to pay. Endorsement from holder in due course. So if someone obtained this instrument from holder in due course, he was already in due course and he gave it to some other person, then all the rights will be transferred to that person. So these are the rights and privileges of a holder in due course. The next I will explain in next video. Thanks for watching.